A 2.4 million capital gain, a carefully structured plan, and a result that completely changed when the case reached the higher court. Everything in this structure follows steps that many business owners and advisors are familiar with: a transfer, a corporate change, a sale. On paper, each step looked acceptable. The plan even worked at the first level of court. But when the case moved forward, the focus shifted from what was done to why it was done. And that shift changed everything. Hi, I'm Amandeep Singh, CPA from Cloudiverse CPAs in Burnaby. I work with business owners and landlords on corporate tax strategy, helping them plan transactions in a way that stands up when the CRA takes a closer look. Let's walk through what actually happened in this case. The owner was holding shares that were about to be sold. The sale was expected to create a capital gain of about $2.4 million. So a plan was put in place before the sale went through. First step, the shares were transferred into another corporation using a tax-deferred rollover. In simple terms, a rollover allows you to move assets from one company to another without triggering tax right away. The tax is deferred and shows up later when the asset is eventually sold. After that transfer, the new company had one main asset, those shares. Then came the key move. Within a short period of time, that company changed its legal jurisdiction from Canada to the British Virgin Islands. Now, here's the important technical point. You see, the company's management and control stayed in Canada, so it remained a Canadian tax resident. But because it was no longer incorporated in Canada, it no longer met the definition of a Canadian-controlled private corporation. So, in simple terms, it was still a Canadian resident company, but it was no longer a CCPC because of where it was legally incorporated. That distinction became central to this case. Shortly after that, the shares were sold and the capital gain was realized. Now, an important detail here, which you need to pay attention to, is that the company accepted that these steps were avoidance transactions. So the court was not debating whether this was tax planning or not. The real question was whether the outcome matched the purpose of the tax rules. You see, at the tax court level, the judge focused on the wording of the law. The reasoning was straightforward. These rules apply to CCPCs, and at the time of the gain, this company did not meet that definition. So, based on that, the result followed the law. But, you see, as expected, the CRA appealed, and the Federal Court of Appeal looked at the same facts from a different angle. Now, instead of focusing only on the wording, the court looked at the bigger picture, what these rules are actually trying to achieve. One thing the court pointed out right away was nature of the evidence. There were no witnesses, no additional documents, just agreed facts and the continuance paperwork. So, the court focused entirely on the structure itself. First, timing. The rollover happened, then within days, the company changed jurisdictions, and shortly after that, the shares were sold. The court treated this as one connected plan. Second, business purpose. The court looked for a real reason behind moving the company to the British Virgin Islands. The evidence showed that nothing operational changed. You see, the management still stayed in Canada. The court described the move as having very little real impact beyond the tax outcome. And third, the purpose of the tax rules. The court referred to a long-standing principle in Canadian tax law. Investment income should be taxed in a similar way, whether it is earned personally or through a corporation. To support that principle, there are specific rules that limit the ability to defer tax when investment income is earned inside certain corporations, particularly Canadian-controlled private corporations, also called CCPCs. In this case, the structure allowed the company to step outside those rules right before the gain was realized. And this is where the court made a very important point. If this type of planning is allowed, then those anti-deferral rules became optional in real practice. And that is not how the system is intended to work. The court also addressed the earlier reasoning that a company can move from one tax regime to another. The court agreed that a change in status can happen, but it also made it clear that this does not stop the general anti-avoidance rule from applying when the overall result does not align with the intent of the law. Now, there was also a discussion about advantages and disadvantages of moving out of the CCPC regime. You see, the earlier decision suggested that there are trade-offs. The appeal court looked at that and said those downsides were not meaningful in this situation. The structure was designed to achieve a specific tax outcome, and the result simply reflected that. So the court concluded that the transactions worked together to avoid the anti-deferral rules in a way that went against their purpose. And because of that, the general anti-avoidance rules was applied. In practical terms, that means the tax benefit was unfortunately denied. The company became subject to the tax that would have applied if those rules had been followed right from the beginning. The court also clarified something important. Applying these rules focuses on removing the tax benefit. It does not change anything else around it. Let me give you an example. The company argued that a different reassessment timeline should apply. The court did not accept that because the rule is focused specifically on denying the benefit, not rewriting other parts of the system. The court also noted that legislative changes were later introduced to address planning of this nature, although the decision itself was based on the law as it existed at that time. So, what does this mean in practical terms? For businesses, it means that the structure alone is not enough. For advisors and CPAs, it highlights the classification changes, like moving from CCPC to a non-CCPCs, need to be supported by real substance. Because when the CRA reviews a file like this, the focus quickly shifts to the overall result and whether that results align with the purpose of the law. At Cloudiverse CPAs in Burnaby, this is where we spend most of our time with clients. You can think of Cloudiverse as a guide that helps you navigate different paths in the tax system. There are often multiple ways to structure a transaction. Our role is to help you choose the route that is both efficient and aligned with how the rules are meant to work. Our focus is primarily on corporate tax strategy, planning restructures, preparing for sales, and making sure each step is supported by proper reasoning. If you are planning a sale or restructuring, it is always worth reviewing the structure in advance so that everything aligns properly. Thanks for watching, and I'll see you in my next video. Until then, bye.